Hello, everyone. Thank you so much for joining us today. We're going to get started in just a second. Chat has been disabled for this meeting, but there is a Q&A field where you're welcome to write your questions at any time throughout the webinar. My name is Luke McLeod, and I use he, him pronouns, and I'm a librarian at Vancouver Island University. This webinar is being recorded for educational purposes, and transcription has been enabled if you would like it. I'd like to start us off in a good way by acknowledging the land that we're gathered on today, wherever it is that you might be joining us from. Let's take this opportunity and speak to some history about the land here that I grew up on. For myself, I'm an uninvited settler of Scottish, English, and German descent that is joining today from VIU's Nanaimo campus, which is located on the traditional unceded territory of the Snuneymuxw First Nation, where I'm grateful to be able to live, teach, learn, and share knowledge. A particular area that I've enjoyed here throughout my life is the Nanaimo River. I used to swim under the Cedar Bridge as much as I could each summer. If you're familiar with the area, no, I have never jumped off the bridge, no matter how many of my friends did. But this area has been in the news off and on for some time. As part of one of the Douglas Treaties between the Snuneymuxw and the Crown in 1854, villages, marine areas, and their way of life were to forever and always be protected. However, 58.3 acres of this land, including the very area where I learned to swim, was stolen and given to settlers, and it's remained in the hands of third parties ever since. This land included the southern portion of the historic Tedahan village on the east bank of the Nanaimo River, and this land had served as a site for cultivating potatoes, commas, hay, fishing, and gathering. The nation has worked ever since to try and achieve a settlement that they believe offers fair value for these wrongs. In 2015, they were offered $5 million in compensation for those acres not being protected. I'm pleased to share that in recent news, nearly 100% of the Snuneymuxw First Nation voted in favor of a settlement offer from the federal government. If you'd like to learn more, there's an information package linked on the front page of the Snuneymuxw website. And I hope that this powerful example of resilience and pursuing a way to move forward can help to inspire the conversation that we're going to have today in this webinar. Our first speaker will be Dr. Ajay Shrestha, who will present findings from his Office of the Privacy Commissioner funded research project on youth privacy and AI. Following this talk, there will be a chance to ask questions, so please add them to the Q&A if you like. After the Q&A, we'll take a 5-minute break to stretch and set up for our second presentation by our guests from the Ministry of Citizen Services, Colleen Rice, Kirsten Nicholson, and Caitlin Buck. I'll give them a proper introduction at that time. It's my pleasure to introduce Dr. Ajay Shrestha, who is a computer science professor at Vancouver Island University and an adjunct professor at the University of Saskatchewan. His research focuses on privacy-preserving technologies, including blockchain, federated learning, and ethical AI. He specializes in smart contracts engineering and data trust, developing frameworks that enhance trust, transparency, and user control. Funded by the Office of the Privacy Commissioner of Canada, his work addresses privacy concerns, particularly for young digital citizens. Dr. Shrestha's contributions have earned widespread recognition for advancing ethical and secure AI practices. Over to you, Ajay.
Thank you, Luke, for that introduction. I'm going to share my screen first. Can you see my screen here?
Yep.
All right, so good afternoon, everyone. So today I'm going to present on this theme, which is advancing youth privacy in AI. So this is part of my research project, which is funded by the Office of the Privacy Commissioner of Canada. And today I'm going to talk about some of the findings of this research and also to introduce you the new privacy model, which is Privacy Ethics Alignment in AI, PEAI model. So let's begin. Okay, let's start with the introduction. The topic. So the youth privacy in AI system is the main topic related to my research project. So when I say, AI related systems. So basically they are everything that we see online, like the social media platform, the education, the gaming environment, giving context, and even the recommendation algorithm that we see online, right? They are all powered with AI or linked with some machine learning algorithms directly or indirectly. Um, but the thing is, have you ever stopped to think about how much data is being collected by those AI systems, especially from the vulnerable groups like young digital citizens or young users? So that's exactly what my research is focused on. As you all know that AI is advancing so quickly, and young people, uh, they often have very little say in how their data is used. And many even don't realize that there are some risks associated with using such AI systems, especially regarding their privacy. And my research aims to bring these perspectives together to find real solutions. And just to acknowledge the Office of the Privacy Commissioner of Canada's contribution programs, that they are actually funding this research. Um, and this research is not just about identifying the problems. It's more about trying to make AI more ethical, more transparent, and more privacy friendly. So the thing is, at the end of the day, so the technologies like this AI enabled systems, uh, they should empower all of the users, including young digital users, not just put their privacy at risk, right? So um, I'm going to add some more content here. That's the research questions. So this is how our research has been guided. We have 5 research questions associated with this project. The first one is how youth develop privacy rules with AI technologies. And the second research questions that we are trying to answer through this research is what are the roles of parents and educators in shaping their kids' privacy boundaries? And the research question 3 is on the influence of risks and benefits on the disclosure of privacy information. And also research question 4 is we'll talk about actually the impact of transparency and trust on privacy management. And the last research question is on the effect of education and awareness on user control over their personal data within AI systems. So we're trying to answer these questions through our research, and we have been conducting a couple of studies already. And in today's presentation, I'm going to uh, talk about the latest model that we have developed. It's called PEA AI model. That's privacy enhance or privacy ethics alignment rather in AI model. So this is actually a new model, but it has been developed during our research. So I can say that it has been developed through the grounded theory approach. So that means the findings, they are basically derived from the real data of the stakeholders who are involved in this study, all of the participants. So we use their real data, their uh, you know real experiences to come up with this model. And this is actually not just the model, this is actually the process of developing the model. All right, so this is a grounded theory that basically follows this structured cycle, as you can see in the slide. This model is for, in our case, it's for making AI systems more ethical, um, more transparent, and more user-centric. Okay, so on the top right corner, you see there, that's a stakeholder's perception. So it starts with that phase where we aim to understand how different groups view privacy in AI. So all of the different stakeholders like young people, parents, educators, even AI developers and researchers. So all of their input forms the foundation of this model. And next is data integration. So where we combine all sort of qualitative and quantitative data uh, to see the full picture of privacy concerns. And then we have the actual, this main framework development phase where we develop a framework. Okay, so we actually developed a negotiation-based framework, and we gave it a name, PEA-AI, Privacy Ethics Alignment in AI, that reflects the needs of all of these stakeholders, and that also makes sure that no single group is left out. And after that, we have policy alignment, so that ensures AI privacy rules match what people actually expect. So they are realistic and they are effective. And once aligned, we go to the next phase, which is ethical implementation. And that basically focuses on applying those rules in AI systems. That is to make the privacy and transparency not just like some sort of add-ons, but they are like core components. They are the built-in features. They should be the built-in features. And finally, we have the continuous evaluation um, because uh, because everyone knows, right? So this privacy is not just a one-time fix approach. So as AI evolves, so do the privacy risks. So we need to keep on reassessing. We need to keep on, improving the policies that we have to keep AI ethical, to keep AI fair and user-friendly. So privacy should be considered as the main fundamental part of AI development and AI governance. And that's what we are trying to incorporate with this PEA model. And in the next slide, you see the actual, this PEA model that we have used in our study, in our research. So on the left side there, we have all of the stakeholders. In our case, we used three stakeholder groups. The first group is for AI, young digital citizens. They are youths. The second group is for parents and educators, and the last one is for AI developers and researchers. And they're linked to the actual final output, is the ethical AI context through some items. All right, so we have 13 of them. So they are all the factors which are responsible for ethical AI development. And this basically represents the actual PAI model, where we gather insights from stakeholders that leads to the development of ethical AI. And all of these items, they are actually categorized into different constructs as well, so which I can show you from our next slide. So there are 5 constructs which define those 13 items. The first one there is DOC, that's the data ownership and control. Second one is PDS, that's parental data sharing. The third is PRP, that's perceived risks and benefits. The fourth one is TT, that's a transparency and trust. And the last one is EA, that's education and awareness. So all of these constructs, they are validated constructs. And all of the items, they are also validated items. So we've done the literature review, extensive literature review, to gather these items and categorize them into different constructs there in order to build our model. So next here, I'm going to add a little bit content regarding the methodology that we have completed in order to just get the data from our users, participants rather. So we got the ethics approval from VIU's Research Ethics Board, and then we started these studies, right? We had first surveys where we gathered more than 480 responses, and after cleaning, we got 461 valid survey responses. Among them, 127 were from parents, educators, 146 from AI professionals. They include AI developers and researchers, 151 from youths, young digital citizens of ages 16 to 19 years. And also we conducted 12 interviews and 2 focus group studies. So we have both the quantitative and qualitative data from our study. And then we started analyzing the data. So we did thematic coding for the qualitative data, and for the quantitative analysis, we conducted descriptive statistics, PLS-SEM, that's partial least square structural equation modeling, using a tool that's called a Smart PLS tool. And we have some results to show you. I'm trying to just add a couple of results here to give the overall, findings of our research. The first one here is the bar chart showing different stakeholders and different constructs as well. Okay, so the blue one is there for young digital citizen, orange bar is for AI developers and researchers, and green is for educators and parents. So as you can see in the chart, so there's a range from 0 to 5. So that's for the 5-point Likert scale. That's what we have used in this study. So it basically tells us something very important as well. So like for AI system, this is for AI system. And if you look into the construct data ownership and control there, AI, I mean, professionals there and educators and parents, they seem to care more about governance and control than young users or young digital citizens. Because young users, they might not feel as empowered as managing their private data. And next over there is parental data sharing. That is also kind of like a rated lower, not just for young digital citizens, but also for AI developers and parents group as well. But in comparison, we have that parents and educators showing slightly more concern. That's slightly because they likely play a role in guiding youth to, some sort of like decisions regarding sharing their data on the AI-based systems, right? But the biggest contrast over there is the privacy risks and benefits. Young users and educators, they see significant risks, but the AI researchers seem to focus more on the benefits. So it basically suggests a kind of like a gap in which these different stakeholders have different perceptions, right? And also for the transparency and trust, there's kind of like an agreement across all groups. That is kind of like a key issue, right? Meaning that AI systems need kind of clear, more trustworthy policies. And finally, the last one over there is education and awareness. So AI researchers rate this the highest, meaning that they recognize the need for better AI literacy. But on the other hand, there are young users and educators, they are also there, but they follow closely behind. So what I want to try to say through this chart is that it's pretty simple. Privacy is not one size fits all context, right? So different groups, they have different priorities. And if we want ethical AI, we need policies that reflect all of these perspectives. So that's very important. And next here, I have another similar, output here from our research. It basically shows the similar results, but here instead of having constructs, we have all of the individual items representing those constructs. I just wanted to just highlight the important findings from this interpretation of this, heat map. So in terms of this, data ownership and control, there, the stakeholders, they basically differ on data control. With educators and AI professionals, they have like a very much support towards strict governance, while I mean, not the AI, but while the youth, young digital citizens, they feel less in control and hesitations to share the data, right? And next, I can talk about this parental influence and youth autonomy there. Um, Parents and educators, they basically advocate for stronger parental rights, whereas youth and AI professionals, they emphasize youth autonomy in managing the personal data. Not just youth, but also the AI professionals, they emphasize that particular idea. Um, and also for the transparency and trust part, so the thing is, all groups basically find the current AI systems not so transparent, right? All of the AI measures, they are insufficient at the moment. And youth actually shows the highest skepticism towards AI data governance as well. And regarding AI literacy and education part, the AI privacy knowledge gaps are there, especially among the youth and educators group there. So this basically recommends that we need greater educations, we need more awareness programs for responsible AI use. Okay, so from here I can take you to this new findings about the results from our structural equation model analysis. So we have individual model for each stakeholder group. So this one is for the young digital citizen, and there's another one. This is for the parents and educators, and this is for AI professionals. So structural equation modeling analysis is actually conducted to see the relationship of one construct upon another construct. All right. So here, I just want to give you a brief overview here. All of these circles here, they basically represent the constructs. So like EA is there, that's for education and awareness. TT is for transparency and trust. DOC is data ownership and control. PRB there, that's perceived risks and benefits. And the bottom left is PDS, that's parental data sharing. And all of the lines with arrowheads, they represent the path between those constructs. And the numbers there, the first number is actually the beta, which is the path coefficient. And in the parenthesis, that's p-value, which basically represents the significance of that particular relationship. And in our findings here, only two of the paths are statistically significant in case of this young digital citizens category. So which basically represents that EA, that's education and awareness, has significant positive effect on perceived risks and benefits. That means if youths, if they have gotten proper education and awareness regarding the privacy, then they tend to understand the risks and also the benefits associated with that particular system, and that leads them to have some sort of ownership of their data. So they want to have full control over their data. So which is also the result of that EA, that's education and awareness. And we have some other findings also. We can interpret all of those things from this structural equation model. Same for here with the parents and educators and AI professionals. But I want to just move into like a new section here, which is the qualitative insights. All right. So besides those, quantitative analysis, we also conducted the qualitative analysis, and we came up with these, context here. The first one is the risks. The different stakeholders, they have given their responses, and after conducting the thematic analysis, we came to the conclusion that the most concerning risks are the privacy breaches, data misuse, lack of consent, and ethical concerns. So these are actually associated with the risks within AI system. And for the benefits, they also pointed out personalization, improved services, and educational advancements as the benefits of using AI systems. And regarding other privacy concerns, they are excessive data collection, lack of transparency, and user profiling. So they are associated with concerns regarding the use of AI system. And they've also highlighted some of the solutions. For example, transparency. So they want the system, the AI system, to be transparent so that they can have more trust on that system. Selective data use, anonymization, aggregation, and also user empowerment. So they want to have control over their data when they use such systems. And these findings basically complement our quantitative findings. So at the end, I would like to add the final guidelines regarding the ethical use of AI and ethical AI development, right? So the first part over there is for AI developers and policymakers. So the thing is, when we talk about having ethical AI or making AI more privacy conscious, different groups, they have different roles to play. All right. So first, for AI developers and policymakers, the focus should be on privacy by design. So needs to make sure that AI systems have built-in control mechanisms from the start. the transparency is also a key factor, because if people don't understand how AI works, right, they may not be able to make informed decisions. So clear policies, better communications are essential. Um, and for educators and parents over there, the priority is AI literacy. Okay, so many parents and even the teachers, they struggle to keep up with AI advancements. So bridging that knowledge gap is very important. It's very crucial, and we need some, structured uh, consent process as well, like the parental consent that respects how young people want to share their data, while also ensuring that their data is protected, right? And also talking about the youths and end users, it's also about the empowerment thing, right? Because AI system should be actually, user friendly when it comes to giving services to the end users. Uh, there should be privacy controls so that people can actually manage their own data. And at the same time, the awareness campaigns should be there in order to help them understand both the risks and benefits of the AI. So they can make, smart and more ethical choices, right? So the bigger picture is that uh, the privacy is not just a technical issue, it's a shared responsibility. And every stakeholder group, they has a role in making AI safer and more trustworthy. Um, so with that being said, I would like to also acknowledge some of my students who are still working with me in this research. Ankur, Molly, Austin, Mohammed, Surya, and Julia are currently working under my supervision in this research. And I would like to thank everyone who has shown your interest and support in our work. And if you want to know more about the project, the research, and maybe just to collaborate with us, please connect with me through the email over there. Also, you can just go to this website to learn more about our project and some of the findings from our research. So thank you, everyone. If you have any questions, I'll be happy to answer them.
Thank you so much, AJ. We do have one question in the chat. I'll read that now. It says, "Hi, AJ. I'm curious about whether librarians or other information professionals who work with young people to develop information literacies are represented in your results, and if so, which category?"
Well, yes, we have actually all of the librarians as well at VIU basically participated in the study. We actually reached out to everyone. Um, so if they identify themselves as parents or like educators, then they belong to that parents and educators category. Um, and if they are more into like this AI research, then they belong to the AI categories, AI developers and researchers categories. So we have tried to just incorporate and include the diverse groups of people there. But again, it's not totally towards like just incorporating the global perspectives. But at least like we have three stakeholder groups, which we actually came up from our literature review, and we found those three groups are relevant enough for our study. And yes, we have a librarian as well in our study. Yep.
Thank you so much. It doesn't look like we have any other questions at the moment, but ideas
Okay.
might still be going.
Okay.
So we could transition over to our, oh, I see a new post. Just before you end, I wanted to ask that if young net citizens are 16 to 19, would you say
Mhm.
that more AI literacy education should be included in high school as part of the general curriculum?
Yeah, that's a very good questions. Um, yes, because the thing is we have just used the age group 16 to 19 um, for youth, for young digital citizens in our study. Um, that means they may still be developing their digital literacy uh, because by age 16, they begin to understand privacy trade-offs, right? They begin to understand some sort of like risks and benefits associated with using such kind of system. Even though they are still, legally minor, they are kind of like increasingly making independent decisions about their data. So it's very important to have, the proper curriculum to address the growing needs of trust and transparency with the new technologies, including the AI enabled systems. And it's very important for educators like us to have a dialogue, have discussions with not only our area, but also it's important to discuss with the policymakers because it is not just the responsibility of educators, but also we have educators who are, I mean, not just the educators, but the policymakers who help in providing some strong policies, regulations, and laws. So because we'll have like another presentation today as well, where we have panel from the Ministry of Citizen Services. So as we move into that discussions on AI regulations and legal frameworks, so let's think about how policies can support the privacy, trust, and ethical practices for everyone, including students at the university setting as well. Yeah.
Great question. Thank you. All right, so just give us a moment here. We're going to move over to our next set of speakers. Take a moment to stretch and relax while we switch over to the other slideshow and presenters. Okay, so next we're going to hear from Colleen Rice, Kirsten Nicholson, and Caitlin Buck from the Ministry of Citizen Services. They'll provide a high-level overview of privacy rights, internationally accepted privacy principles, and the application of BC's privacy laws to both the private and public sectors. The discussion will highlight critical topics such as youth data protection, artificial intelligence, and evolving privacy challenges. Colleen Rice is the Executive Director, Strategic Policy, Privacy, and Legislation in the Ministry of Citizen Services. As Executive Director for the SPPL branch, Colleen is responsible for IAM and IT policy and legislation development, including the responsible use of artificial intelligence policy framework. Colleen has worked in a variety of policy and legislation-related positions since joining the public service in 2007. Her experience includes participating in the creation of the Anti-Racism Data Act, the implementation of the Public Interest Disclosure Act, and the development of a modernized Information Management Act. Caitlin Buck is a Director of Policy and Legislation in the Ministry of Citizen Services. She is currently working on policy projects related to artificial intelligence, children's privacy, and private sector policy reform. Caitlin has been a public servant for over 13 years, with previous roles in the Ministry of Health, Ministry of Attorney General, and the Public Service Agency. Kirsten Nicholson is a Director of Policy and Legislation in the Ministry of Citizen Services. She and her team support the ministry with policy and legislation projects related to various issues, including privacy management, information access, and digital identity. Kirsten joined the BC Public Service in 2008, and she has nearly 15 years of experience working in privacy protection. Thanks so much for joining us today. Over to you.
Hi, thank you so much for having us. I know we're all grateful to be here with you today. Kirsten is going to share the presentation that we have here. I'll just give her.
Can you see it?
I can see it, but it's not playing the slideshow. Like it's just, there you go. Okay, so go to the next slide, Kirsten. So I think we got a wonderful introduction from Luke, so thank you very much for that. As was stated, I am the Executive Director responsible for privacy, policy, and legislation in the provincial government. We managed, I think, 25 statutes or laws, not all of them related to information management or technology, But the big ones that we work on quite often are the Freedom of Information and Protection of Privacy Act and the Personal Information Protection Act, which is British Columbia's private sector or privacy legislation. I will apologize in advance because this presentation is actually 3 hours of presentations condensed into one. So you're going to get some pretty high level kind of information. We won't get super technically into the laws, and also we're not trying to be super formal. So if you have questions at any time, please interrupt us and ask. There should be time at the end as well for questions. Generally, we're going to talk at a high level about privacy rights and principles, a little bit about cross-jurisdictional privacy law, and then we'll give you some more detail about the Freedom of Information and Protection of Privacy Act and the Personal Information Protection Act. And while there are many trends or considerations in the world of privacy, we're going to talk more about the work that government is doing on the responsible use of artificial intelligence and some of the things that we've been considering around children's privacy. I should note, while we are responsible for policy and legislation, we're also responsible for privacy operations at the corporate level in government. So we have our privacy investigation unit who investigates privacy breaches, and we also provide corporate privacy advice around privacy impact assessments, et cetera, to all government ministries. So if you can go to the next slide, please, Kristen. So privacy is a core value in our society. Actually written in the Constitution, but it is considered really important to most people in the country. And most privacy legislation around the world are based off these kind of 10 fair information practices or principles, privacy principles. So just to talk a little bit about them. So when you're collecting personal information from people, you should be telling them what the purpose of that information or the collection of that information, how it's going to be used before you collect it, or at least at the time that you're collecting it. You should only really collect the information, personal information that you need in order to carry out whatever your purpose is that you've identified. And in most cases, and we'll get more into it as Kirsten and Caitlin walk us through our two different pieces of legislation, you should be getting the consent of the individual that you're collecting the information from, except when it's inappropriate. There may be times when it's inappropriate, and you should really only keep that information for as long as you need it. So you shouldn't be holding on to it forever. And both of our laws that we're going to talk about today require that there are reasonable security measures around that personal information. You should also, an organization or a government body should have someone responsible for privacy in their organization. And you should be open about your policies and procedures that you have in place to manage personal information, and they should be available, and you should make sure the personal information is accurate. And you should give individuals access to their own personal information and allow them to appeal to have it corrected if they don't think it's accurate or complete. And there's some kind of appeal mechanism if the individual doesn't believe that you have properly corrected or updated their personal information. So we can go to the next slide. So across Canada, there are different privacy laws in each province and territory. In British Columbia, we have and two laws of what we call general applications. So they apply broadly across a number of different bodies or organizations. We have the Freedom of Information and Protection of Privacy Act, which applies to the public sector. And we have the Personal Information Protection Act, which is our private sector legislation. Only 3 jurisdictions in Canada, 3 provinces in Canada have private sector privacy legislation, and that's British Columbia, Quebec, and Alberta. Nationally, we have what private sector privacy legislation that's called the Personal Information Protection and Electronic Documents Act, or PIPEDA for short. It deals with federal works or undertakings. It's pretty technical, but it applies across the nation. So if they don't have provincial privacy or private sector privacy law, they have the federal law. We also have in Canada, they've split their access and privacy legislation into two statutes, where ours is one. And access, I mean, like you might be familiar with like FOI or Freedom of Information requests. I think we can move on to the next slide, Kirsten. So now I'll give you kind of a high level overview. So there's a lot of similarities in FOIPA and PIPA. So remember, FOIPA is the public sector legislation, and PIPA is the private sector legislation. They both have requirements for privacy and access. They're both really focused on personal information. And they both are overseen by an independent officer of the Legislative Assembly. Where they're different, and remember when I talked about the principles, the privacy principles, I talked about consent. PIPA is consent-based legislation, so it in most cases requires consent. The public sector legislation, FOIPA, which Kirsten will tell us a little more about, is what we call authorities-based. So it's not really consent-based, which kind of throws people off a little bit. And Kirsten will talk a little bit more about why it's like that. So authorities-based means that there's some kind of section in the act that allows us to collect the information, to use it, and to disclose it or share it. So I think what I'll talk about before we go into more detail about FOIPA and PIPA is just to give you an idea about the Information and Privacy Commissioner. So the Information and Privacy, the Office of the Information and Privacy Commissioner, and our commissioner right now is Michael Harvey. This is our provincial commissioner, not to be mistaken with the federal commissioner who funded AJ's research that we talked about earlier. Michael Harvey is the commissioner, and he just became the commissioner, I think, last year. The office was established in 1993 when FOIPA was actually first passed, essentially. And the commissioner is actually the most powerful independent officer of the legislature in British Columbia. So they report to the Legislative Assembly. They are not part of government. In fact, much of their mandate is about holding government to task. Commissioner Harvey has oversight over both FOIPA and PIPA, and actually has the powers of equal to a provincial court judge. So they're a quasi-judicial body. They investigate privacy complaints. They mediate. They do mediations. They provide research, or I'm not say by commission research, much like the Privacy Commissioner of Canada. They also can handle. They adjudicate decisions. They have order making ability. They're a pretty strong office. So, for example, they investigated, I think it was a couple of years ago, Caitlin or Kirsten, you can correct me if I'm wrong, they investigated under PIPA Canadian Tire. Canadian Tire's use of facial recognition technology went on customers when they were coming into the store. And then they made recommendations about facial recognition technology that is available publicly. Okay, sorry, I was distracted by the question. I'll come to that in a minute. Thank you. So
do you want me to pause for a question?
No, I think we might need to think about, does the burden of ensuring consent is acquired from users fall on the company selling the AI data collection program service as well, or only on the company that has purchased or is using the? So I think that I need to think about that one a little bit, and maybe we'll move on, and as we go through FOIPA and PIPA, you might actually find your question is somewhat answered. So Kirsten, did you want to talk to us about FOIPA?
Sure, I can do that. Thanks, Colleen. So like Colleen said, FOIPA is BC's general privacy law that applies to public bodies in BC. It's been around since 1993, so it's over 30 years old. There are about 2,900 public bodies that are subject to FOIPA, so it includes government ministries, crown corporations, agencies, boards, commissions, local government bodies like municipalities and regional districts, healthcare bodies, hospitals and health authorities, education bodies, including schools, school boards, colleges and universities, and governing bodies of professional organizations like the Law Society of British Columbia. It also applies to public body employees and service providers who are carrying out the work of those bodies. It is interesting to note that FOIPA does not apply to teaching or research materials. So that's in order to preserve the confidentiality of research and the integrity of teaching materials like exam questions and answers. And it also, FOIPA doesn't apply to court or judicial records. And that's so that it's to protect the independence of the judiciary. FOIPA defines personal information as recorded information about an identifiable individual other than business contact information. So that means that FOIPA does not apply to information that's de-identified or can't be re-identified, but it does apply to details about a person's education or their employment, health, even their personal opinions, and it can include other information from something as simple as a person's name to their home address or even their genetic information. So it's quite extensive in its coverage of what personal information is. Moving on to the next slide here. So like PIPO, FOIPA has two primary objectives, and that's to balance the public's right to access government-held information, including information about themselves, with the need to protect individuals' personal privacy. So these two objectives can sometimes be at odds with one another when there's information or access to information that would potentially violate an individual's privacy rights. On the access side, so like Colleen said, access is also known sometimes as freedom of information or FOI. Public bodies are accountable to the public for ensuring access to records under their custody or control. Under FOIPA, individuals have a right to access their own information, including a right to correct their information if they feel like it's inaccurate. And another important aspect of access under FOIPA is the right to access government records related to government programs, finances, and operations, for example. And we refer to that as open information and open data, and they are fundamental to transparency and accountability in democratic society. There are several exceptions to the access rights under FOIPA that are meant to protect individual privacy, such as, like I mentioned, for third-party information, so another person's personal information. And there are other protections for things like cabinet confidence, solicitor-client privilege, information that could be harmful to public health or safety, and that's just to name a few of them. So the other part, or the other purpose of FOIPA is to protect individuals' privacy. As Colleen mentioned, FOIPA does not rely on consent in most cases and is considered an authorities-based law. So what that means is that FOIPA sets out limited and specific purposes for which a public body can collect, use, or disclose personal information. So if you actually look at the legislation, you can see those purposes listed throughout. So an example is a public body may collect personal information if it's authorized by another law. Like if you are getting your BC driver's license and information is collected from you in order to issue that under the Motor Vehicle Act. Another example is if you're, say, going to the hospital, like the Nanaimo Hospital, and they collect your information, your medical information, in order to provide treatment that is considered a program of the public body. So relating back to the principles, public bodies have to limit the collection, use, and disclosure to only what is necessary under the circumstances. So it means that public bodies can't collect information and hold on to it and decide that later on they'd like to use it for another purpose. The rules in FOIPA are meant to ensure that public bodies are collecting the right information from the right person for the right purpose in the right time and in the right way. Under FOIPA, unauthorized collection, use, and disclosure by public bodies is an offense. And like Colleen mentioned, there are security and other requirements on public bodies to ensure that they're taking reasonable steps to protect the personal information that they hold, to make sure that it's appropriately protected from unauthorized access, use, or disclosure, and to ensure that they do things like conduct a privacy impact assessment before they start a program that would be collecting personal information. And I think that is it for me, and I will pass it over to Caitlin to talk about PIPA.
Before you do, what was interesting and often surprising for folks is that BC government ministries themselves, so there's 23 ministries, and then 24 if you include the Office of the Premier, they're all separate public bodies. So government is not one big data store that's sharing information across all of it. There's lots of rules around information sharing, even across ministries. So the Ministry of Education and the Ministry of Health, for example, it's people are often surprised to hear that, like, you think of us as one government, but from a privacy perspective, it's actually a bunch of different public bodies under the legislation.
That's a good point. Thank you.
So hopefully, Luke, Caitlin may answer your question that I see in the chat as she talks about PIPA.
Okay. So PIPA is, it's the private sector privacy law. You can go to the next slide there, Kristen. So it applies to the private sector, and it also applies to personal information, but there's a slightly different definition of personal information under PIPA. It's identifiable information about an individual. It also includes employee personal information. Doesn't include contact information or work product information. So the things that you create as an employee. So it doesn't include that work product information. It also doesn't include non-identifiable or aggregate information. So statistical information about groups of individuals is not personal information. And an interesting thing about PIPA is when it applies. So it applies to businesses operating like physically in BC or providing services in BC. And that's an interesting distinction because that means it applies even to foreign businesses lacking a physical presence in BC. And that was recently upheld by the Supreme Court in a decision related to Clearview AI, saying that even though Clearview AI does not have a physical presence in BC, they were operating in BC, and therefore the law applies to them. And then the other interesting thing about when is, like Colleen was talking about, there's a federal private sector statute, and that applies to federally regulated things, even if it's within the province. And those are things like banking, telephone companies, airlines, shipping, and that's because they're like within their jurisdiction. Okay, next slide, please. I'm going to talk about two main differences between FOIPA and PIPA. The first is the right of access. So under PIPA, people only have the right to access their own personal information, whereas under FOIPA, like I could do an FOI request to get information about policy that a body has, which is not my personal information. But that right of access under PIPA it doesn't include work product information. So that means that the information I generate as an employee can't be accessed through an access request. And there are limited exceptions to right of access similar to in FOIPA. Next slide, please. The other main difference that we've already spoke about a bit is that PIPA is a consent-based statute, whereas FOIPA is more authorities-based. So that means that businesses must have consent from an individual before they collect, use, or disclose somebody's personal information. And there are parameters about what meaningful consent is. So that means they have to have the consent should have a clear purpose, explaining like why the information is being collected, used, or disclosed. To be informed, so you need to know about the purposes that it's like the information is going to be used. It should be voluntary and specific. I'm sure we've all ignored privacy notices. This is some of the information that's required in law. And there's they make a distinction about capacity to consent. So you need to be able to understand the nature and consequences of giving consent. And that is quite contextual, right? Like, so somebody can have the capacity to consent to one type of information sharing and not another based on the severity or the context. And you should have the ability to withdraw consent. I won't go into too much detail, but there are 3 types of consent in PIPA. So to make a distinction about when you can imply consent versus when you need to have like explicit written consent. Okay, and on to the other, it's not a difference between FOIPA and PIPA, but I think it's an important thing to know about private sector legislation. So harmonization is really important, and it's becoming more and more important as businesses operate, across provinces, across the whole country or even internationally, right? So having harmonized rules reduces the burdens on businesses, especially those that operate across Canada and internationally. And I think that it's also it's really important within Canada, like from our perspective as policy, like dealing with policy, we need to really be mindful of what the federal government is doing with their law and align with that, make sure we're similar to those provisions, and same with other provincial jurisdictions, just to make it easier for businesses in Canada. And then to add the other layer, it's when you go internationally, right? Like if it's a business that's also operating in the EU, they have different rules, and you need to be mindful of that so that a business can comply with all of those rules.
So why don't we pause there and think about before we move on, because some of these are really specific questions. So one is, does the Privacy Commissioner of BC have the ability to investigate private businesses or organizations on their own, of their own will, or is it complaint based? So I think like the short answer is yes, they can. But often they probably get interested because they've got complaints, and maybe they've got more than one complaint. And so that drives them to carry out that investigation. They can investigate the public sector, I think, probably more than the private sector.
I think that so you can have an investigation, which is complaint based, or an audit, which is just like, hey, I want to see what you're doing. So that's of their own will. I think you kind of have more powers if there is an investigation, meaning there's a complaint with respect to the recommendations and the tool, like the enforcement tools they have in their chest. Whereas if they're just auditing to see, they would just produce recommendations, and then they would have to then go back to check to see if that business has not complying. So they have both, but like it's how powerful they are, and they're always like, everybody's limited by resources, right? So they have a specific number of tasks, and they have to prioritize certain things. They probably prioritize complaints over kind of
random
going
audits.
in. Yeah.
So the first question that we got was, I spoke to a business owner of an AI data collection service a couple of years ago, and they mentioned that they couldn't verify that businesses they sold their program services to were asking for proper consent before using the service to collect user data. Does the burden of ensuring consent is acquired from users fall on the companies selling the AI data collection program service as well, or only on the company that has purchased and is using the service for data collection? I don't actually know if I feel like I have enough to give you an answer right now. That's something I could take away. It's pretty,
I think,
unless you guys think you have.
well, I can answer the first part of it, that if the business is selling the information, whether like for whatever purpose it's going to be used by the receiving company, they would have to get some sort of consent from the individual. So often in those policies that Caitlin mentioned, it will be a lengthy policy, and it will speak to the fact that they may give the data to third parties, or they may sell it or something like that. How that third party uses it, beyond that, it kind of just depends on what's actually in that policy that the person has consented to. And it does come up in the case that you mentioned, this Clearview AI. It's actually indexed as Facebook, but that was the issue, that Facebook was taking the information and selling it to Clearview AI without necessarily having the consent of the individuals or them knowing that that was happening.
But if this is a tool, like I'm an AI developer and I create a tool and then I sell it to Colleen, and Colleen uses it in a certain way, Colleen is responsible for getting the collection, like like ensuring consent from individuals, assuming I no longer have any access to that. But it is kind of like a long-standing argument. Like you'll see this like in like apps. So it's like, who has, like, does Apple have any responsibility with respect to apps that they have in their app store? They would like to say no. And then other companies say, well, like the app store should verify age. So it depends on which side you're on there.
Yeah. So then one other question before we move on, because we just have a few more slides, is I wonder if you could mention any specific cases where recent technological developments have prompted a review or change in BC's privacy policies, and if any, how long it takes to add policies with these rapid changes in AI innovation. Okay, so I'll start and you guys can fill in. Privacy laws are supposed to be, because they're laws, like we said, that generally apply across a wide variety of organizations. They're meant to be technology agnostic. So the rules around collection, use, and disclosure shouldn't really have to be significantly changed because of a technology. We've seen, the move to cloud. We've seen the fact when FOIPA was created in 1993, I don't think we were even really using the internet. Like there's been a lot of different technology advancements, and FOIPA has stayed basically true. What I will say is that our FOIPA in British Columbia before 2021, well, I think it was between 2007 and 2021, had what is called data residency requirements. So personal information had to be housed inside of Canada unless there was it doesn't really matter. There's specific exceptions. In 2021, we did amend FOIPA to take that requirement out, and we added additional requirements around privacy impact assessments. And I think that you could see is the move to more cloud-based tools. The pandemic certainly highlighted when everybody had to stay home. Many educational organizations, whether that was a college, university, or K through 12, couldn't use some of the tools that they really needed to use. And so we had to use that order making ability to allow that. And so in 2021, we actually made the change permanent. That doesn't mean that information is any less protected. It certainly is very well protected. But I would say that's probably an example where I can think, because we have this data residency requirement, that we made a change. Laws in particular are not easy to change or to make. They're quite a substantial effort. So you can't change a law. Well, most of the time you can't change a law in a number just in months, right? Policies are easier to change.
I think I would just add that, like, the fair information privacy principles, like they're sort of underpinning the legislation. So with those principles, they'll apply no matter what technology you're talking about. And that's why they they can stand the test of time with changes in technology.
Yeah, the only thing I would add is that the commissioner has one of the roles of the commissioner is to comment on privacy implications of new technologies, and that's what they do in the report. So like the report that Colleen mentioned earlier about Canadian Tire and facial recognition technology, that's something that the commissioner feels very strongly about. If you go through that report, which I'm sure it's kind of
everyone's going to run to do that.
But anyway, basically, it's kind of interesting. You read it all and you see that it goes through all the privacy principles, and the end conclusion is that there's basically no world in which you can have a camera doing facial recognition in a store legally, because you need to be able to opt out. Like, people would be able to say, no, I would like to not be have my face captured for the system, and that's just not technologically possible. So so I think they use their reports and investigations to comment to be more specific around a technology, even though the general privacy principles are in the statute.
I think I would just so people don't think we're it's not that facial recognition technology is never allowed. It's just the way that Canadian Tire was using it. The commissioner found that you had to get consent every time a person came into the store, and signage wasn't enough. And it was specifically around the capturing of your biometric data, your face, right? Okay. So maybe we should try to get, because I know that we're probably coming up on time. So Caitlin and the team in my area have been working on AI policy probably for, I don't know, it feels like forever, but it's been, I think, maybe 2 years, not quite.
Almost, yeah.
So we have started by trying to understand how AI was being used in the provincial government. As we know, AI is not a new thing. It's not a new thing. Gen AI and the explosion of ChatGPT really kind of highlighted and brought it back to the front and created this hype cycle. We've been looking at what other jurisdictions are doing. What do we need to align? How do we align? What tools policy tools do we have that already address AI in BC? So we talked about FOIPA and the privacy laws applying, but human rights law still applies. Intellectual property law still applies. These are all the same kind of laws of general application. BC's looking at different use cases. The challenges when developing this policy, and where you'll see draft AI principles or interim guidance, is the tech is evolving. We were a long time ago, it feels like, I was experimenting with Google LM Notebook, and I dropped FOIPA, the actual act, into the notebook and asked it to find me all the mandatory exceptions to disclosure. So the reasons why you would withhold information in an FOI request. And it routinely missed cabinet confidences. And then yesterday I tried to do it again to recreate the mistake, and it's gotten better. Now it doesn't make the mistake. So I was like, I was going to use it for a presentation that we're doing next week, and they fixed it, so I can't. But we also want to take advantage of how AI can help with service delivery to citizens, how it can make it more efficient, how it can give more information to people. So it really is a balance, and recognizing it's also not just a privacy thing. It's not just a security thing. It is a multidisciplinary challenge with respect to equity and fairness and administrative fairness. So I'll just look at this question. The link to the, well, there you go. Now you can go. Okay,
I'll put you to sleep tonight.
Yeah. The next slide, please. So we developed draft responsible use guiding principles for AI. And then we consulted with public servants. Initially, we spoke to over 4,000 public servants in person or virtually. and we took, and we had a survey, we had a bunch of stuff, and then we took that feedback and we edited or updated the principles into like their second version. And then we consulted on those with the Information and Privacy Commissioner, the Human Rights Commissioner, and the Ombudsperson. And then we published all of this in November of last year. I will try to find you a link and drop that into the questions and answers. So all of this is public facing. We have principles, we have examples. The ministry success stories will tell you the different ways government is using, or examples of the different ways. So my favorite one is always like stopping the burn, I think they call it. It's like wildfire prediction. We have like a kind of an AI 101 primer, because as AJ mentioned in his research, public servants, they're either, have you not seen the Terminator? Like, what are you doing? Or we don't want any rules, get out of our way. And then everywhere in between, there's, what is AI? So this is more of the level setting initially. We have interim guidance on the use of generative AI, which we had to put out quickly because of ChatGPT, which basically says, don't put confidential or personal information into Gen AI. Use it, but be mindful of that it can lie to you, and you need to monitor like the wording. So that's our general guidance. We are working on more updated guidance. And as I've noted in this meeting, there is an AI note taker in this meeting. Public servants are going to meetings with external partners like Indigenous nations, Indigenous peoples, local government, so like cities, and these virtual meeting assistants are showing up more and more. And some of them are pretty benign. They're just taking notes, like the note taker in this meeting. Sometimes, though, they summarize like your reactions. So Colleen said, and then Caitlin looked shocked. And so it's basically some instruction for employees on how to move forward when they encounter that situation, or how they set up meetings in a good way. Because we also appreciate that these AI assistants also provide accessibility services to people. Thank you, Caitlin. Can you go to the next slide, please? So these are the 6 principles that we have now. Will they change over time, and will their underlying wording guidance change over time? Probably. But they're here to stay for a while, and they're about transparency, accountability, public benefit. We changed from human-centric to public benefit because it didn't really resonate with folks. Fairness, reliability, and safety. They're meant to be really high level. They're not really prescriptive because they're not meant to sit over one particular use of AI or one particular type of AI. As we move through this space, I'm sure we will have more prescriptive policies or procedures or guidance for folks. But right now, that's kind of the high level. So I think that is kind of the end of responsible use of AI, and I'll hand it over to Caitlin to talk about children's privacy.
Okay, so the internet has changed how we share and consume information, and particularly for children, right? Like, it's increasing educational opportunities, but has safety and privacy risks. And it just so happens that children are particularly vulnerable to those privacy infringements. So there are many apps and websites that collect, kids' information, but they also sell it. And there are things that companies like, so kids are pretty vulnerable to things like over collection of personal information, a lack of informed consent. And so like basically companies know this too. And so they can do things like deceptive design practices to over collect. So you can, make it, collecting more information option flashier and easier to pick. This is an interesting issue because it's generally like private sector companies make a lot of these tools, but there are some public sector organizations that use them for children, right? So like over the pandemic, when education went online, there was a lot more, there were a lot more apps and online tools used for children's education. And there have been reports of that time where like even like it was like almost all of the online tools endorsed during the COVID pandemic by governments infringed on children's privacy. And so I think that this is also a challenging area because children's privacy is often conflated with online safety. And online safety is much broader. So online safety includes things like cyberbullying, online predators, like exposure to inappropriate content, and paradoxically, in order to enhance online safety for children, you sometimes have to infringe on the privacy rights of children or all users, right? Like, so if you're going to age verify on the internet, you have to collect information, more information than you normally would to do that. And this is a problem internet, like globally, right? Everybody's struggling with this now. There is this need to protect children but also preserve their rights. And it's just more and more challenging with like social media and an online world. There are some things that jurisdictions are doing. Like there are some laws that bolster children's privacy rights to varying degrees, right? So it's to add more protections for children's information. To make it more sensitive or give them more control, like the right to erasure. And then there's other things like the UK has an age-appropriate design code that is a set of 15 flexible standards, and it's a risk-based approach. So going back to AJ's speech, it's really based on that privacy by design principles, and that's for companies that make apps or tools that are likely to be accessed by children. And that's another challenging piece is that like there is no kids internet and adults internet necessarily, like and it's a challenge to say like what is designed for a kid and what isn't. I know we're running low on time here, so I'll maybe I'll end that there and open it up for questions.
Thank you.
Thank you so much for giving that talk. That was really interesting. Do we have any more questions, dear participants? Well, while we let people think, I just want to extend my gratitude to all of our speakers today for joining us. Thank you so much for sharing your knowledge, your expertise with us. And I also want to thank all the participants for their time, attention, and their questions. I also want to promote that there's going to be a follow-up event to this in the Nanaimo campus on March 12th from 11 to 2 p.m. in the Madrona room in the library, and it will be catered.
I'm there.
Right? More information about that will be released later today. So I hope to see folks there. Look out for it next week on the event sheet. I'm still not seeing any questions, but thank you all so much again for your presentation.
Thank you for having us.
Thank you.
So maybe we'll end it there. Take care, everyone, and have a wonderful rest of your day and weekend.
Thank you.